I've seen it before, it happens all the time. You're closing the door, you leave the world. Hi, I'm Kristen Lawhorn, and I am the managing partner of Holden Litigation's Texas office. I am also an 11-year attorney and a graduate of SMU's Dedman School of Law. Today's episode is being recorded at 11 a.m. Eastern Time, 8 a.m. Pacific Time on Thursday, March 4th, 2021. Whether you live in Texas or have been watching the news lately, you are very much aware of the Texas winter storm. The Texas winter storm, which is also known as the Big Freeze, is the largest storm in Texas history. And not only that, it will almost certainly be the largest claim event in Texas state history. Preliminary estimates for Hurricane Harvey, which occurred in 2017, predicted that the eventual damages would total $10 billion. Well, those damages ended up totaling a total of $19 billion. Well, it's a brand new day and it's time for Hurricane Harvey to move on over because the Texas Big Freeze is here. Early estimates indicate that the storm damage could total between $20 billion and $200 billion. That is just unfathomable. And as you can see on your screen, the plaintiff's bar is already in high gear, and this is a feeding frenzy that has no end in sight. State Farm alone reported 30,000 claims for burst pipes within 36 hours of this event. When you factor in other insurers like USAA, Farmers, AIG, and the likes, we are certain that there will be hundreds of thousands of additional claims to come. Some of these claims are going to include for auto damages, damage to buildings from burst pipes, fallen trees, roof leaks, mold, and of course, business interruption. And where there are storm claims, we already know there's going to be lots of litigation. There will be coverage and bad faith litigation, as well as class actions and multi-district litigation. So definitely be on the lookout for that. The plaintiff's bar is going to ride this wave of claims to the moon and back and take everything they can from them. In fact, the plaintiff's bar is already preparing, much like with COVID-19 litigation, for coordinated insurance claim litigation, which will certainly include class actions and multi-district litigation. Today's webinar is going to address an abundance of topics that are very hot and popping right now. So we are going to be able to discuss with you today class actions, coverage issues, bad faith issues. We will also discuss with you the latest Texas law on accidental water loss and mold claims, the prompt payment and unfair settlement practices provisions of the Texas Insurance Code, and a new decision recognizing negligent claim handling. In addition, we have important information for you concerning appraisal and protections in the tort reform statute that have been put in place to curb excesses of hailstorm litigation. All aspects of the Big Freeze are changing rapidly. Please be sure to note that all of our thoughts, recommendations, and opinions expressed today are current as of March 4th. Also be sure to check out the Texas Big Freeze section of our website at holdenlitigation.com, where we will have up-to-the-minute updates for you concerning the storm and its impact on litigation in Texas. At any time during today's webinar, if you are interested in asking a question, go ahead and type that question into the Q&A box, and we will try to get to that question by the end of the show. If for some reason we are not able to address your question live, we will be sure to answer it for you via email at a later time. So today, let's go ahead and go on and let me introduce you to our amazing panelists. We have Laura Grabouski. Laura Grabouski is a 20-year attorney and she is based in Austin, Texas. She is also an accomplished attorney and is known for her talent in legal writing and coverage analysis. Welcome, Laura.
Thank you. Good morning, Kristen.
It's nice to have you.
Thank you.
And last but not least, we have Steve Holden. Steve is the president and founder of Holden Litigation. He is also a 40-year attorney with an extensive amount of trial experience, which includes over 200 jury trials. Welcome, Steve.
Thanks, Kristen. And I am last and I am least on this panel. It's a pretty stellar group. I have had those 200 plus jury trials, but not of late. We don't try them anymore, I guess. Yeah, I've been there, done that. Thanks, Kristen.
We're very happy to have you both. Now, Laura tracked Hurricane Harvey extensively, and she even hosted a podcast titled Hurricane Harvey by the Numbers. Laura is going to tell us how the big freeze will be different from Hurricane Harvey when it comes to the impact that it will have on litigation. Laura, take it away. I will join you and Steve later to address any questions that our viewers may have.
Sounds great. Thank you. Yes, I did track Hurricane Harvey, and not to diminish it at all, because it had and still has a huge impact on the state, and it exposed a large amount of uninsured properties throughout the state and homes. But as we're saying, and you'll hear us saying today, it is time to move over Harvey, unfortunately, due to the big freeze. Now, Harvey, like most storms that we're familiar dealing with, be it hailstorms in the Rio Grande Valley or the big hailstorm in San Antonio, Bexar County in 2016, those are regional storms. And while they did pack a punch, what's very unique about the big freeze is that it was a statewide event. And while I have heard that there is precedent for it, not in our careers or even lifetimes really, it is a rarity that you would have a singular weather pattern affecting the state. And that is in fact what we had for several days. And you can see this was, I'm sure most, if not all of us heard about, this was the very beginning of the storm that I think it was a Monday. It was this horrific 133 car pileup in Fort Worth on I-35 and resulted in multiple fatalities. You can see the extent of not just the loss of human life and injury, but the damage to those autos, and you can imagine the claims. And there's already, of course, litigation resulting from that. In addition to auto liability claims and auto damage claims, this storm is unique in that it is triggering just your more traditional property damage claims. You had interior water damage. You can look at this. That's the inside of someone's house. That's a ceiling fan. You had from bursting pipes. This was inside, a residence. You had roofs that were frozen over. I don't know where this is, but look at that. I mean, that's just not something that we're used to seeing here in the state. But this was Galveston, and that, again, this was what is making this storm so unique, that you had from the north of the state and the Panhandle all the way down to the southernmost part of the state, where you had these freeze and snow for several days, again, resulting in the types of claims that are triggering policies that are much more predominant among the state. Property owners have property policies a lot of the times. Again, with Harvey, what happened was that many people were frankly uninsured for flood, and then there were flood policies in place, and so those are covered under very specialized flood policies. And then many claims were made, but they were made primarily for the point of being denied, so that it would trigger a FEMA claim. And so that's going to be distinct in the big freeze claims, because there's going to be more claims that are going to trigger policies, because frankly there's more traditional property damage here. Now, another thing that's going to make this the perfect storm, if you will, is that Texas law has undergone some changes, just even in the brief time since Hurricane Harvey in 2017. One big area that we're watching and have watched is in the area of appraisal. And one thing that's been consistent in Texas law is that appraisal is very common. It's standard in most policies. And the Texas Supreme Court for many years has said appraisal is mandatory. Either side can invoke it. Now, there are all sorts of new policies that I'm seeing where there are attempts to make it unilateral, but your standard policy has that if you or I, or the insurance company or the insured disagree on the amount of the loss, either of us can invoke appraisal. And it is mandatory for a court to enforce that. It is mandatory even if there is a causation or a coverage dispute. And it is generally can be invoked even if the parties are already involved in a lawsuit. Now, there are some nuances there, you get into waiver, but they're just very, they are enforceable, and there is a strong policy in terms of enforcing the parties' contractual way to resolve disputes. For many years, there was also a good body of law developing that said, well, if the parties abide by their contract and they go forward with the appraisal, and in fact the carrier pays the appraisal award, well, then that should resolve all of the disputes between the parties. So there's no bad faith, there's no attorney's fees, there's no prompt payment interest. That just goes away, we're done, everything has been resolved. That went to the Texas Supreme Court in 2019 in a pair of decisions, Ortiz and Barber Technologies Corporation. In the Ortiz decision, the Texas Supreme Court agreed for the most part, and it said yes, unless there is this nebulous independent injury. Spoiler alert, it's never been found, but it is available. But barring an independent injury, a payment of an appraisal award is going to resolve any kind of bad faith claims. However, in Barber Technologies Court, the court left open what many feel is kind of a big gaping hole, because it said a prompt payment claim, which gives you the penalty interest, had been 18%. We'll get into this in more detail later, but under Chapter 542A, which was passed in 2017, it's 10% for a lot of these types of claims we're talking about today. But penalty interest and attorney's fees, that claim is still going to be viable even if you've paid the appraisal award. The court further held that the claims can't be resolved on summary judgment, or at least they could not in that case. Court remanded to the trial court to resolve that claim. And so I've even seen where cases have literally gone to trial just on attorney's fees and prompt payment interest. That's the only thing in dispute, and there's a trial, even though everything's been paid and that's all there is in dispute. What's the bottom line? Well, appraisal, there is a huge incentive now for insureds and the plaintiff's attorneys to invoke it. And so we have already seen a marked increase since 2019, since that decision, and we expect to see much more of that. And these types of claims, we think, will be driving that push for appraisal. We are also, as Kristen mentioned in those early slides, the plaintiff's bar is going to be pushing for class action suits. That's something we're familiar with, having gone through COVID-19, just in this past 2020. Now, COVID-19 class action litigation did have something going for from the other side's point of view, in that there were some unifying legal issues. Did a lockdown result in lack of access, lack of use of property, and is COVID-19, is that considered property damage? Those same legal issues are not present here. And so there are some questions about what are going to be the common themes, common issues that would make these types of claims appropriate for class actions. But we know that they are going to be pressing for that, and we know they're already preparing for that. And so we are also preparing and getting into a proactive mode for that. And another area that we are anticipating is the use of the MDLs, the multi-district litigation forum. Those have been used in the past in Texas. Those are where cases are consolidated for, it's multiple suits, but they can be consolidated, say, for purposes of discovery. Those have been used in prior, like natural storm type claim litigation, for instance, in the Rio Grande Valley for the hailstorms in 2011, 2012. So that's another vehicle, and something that we would see where there's going to be mass tort litigation, that would be something that is going to be a vehicle for these types of claims. So speaking about what types of claims these are, as we mentioned at the beginning, the types of claims that we're seeing, and that frankly you are seeing, are lots of burst pipes. You've seen that, you may have even experienced that. And so that led to a lot of interior water damage. Those, they're also seeing roof claims from either the snow, ice, things falling onto the roof, trees that snapped. We see the consequential type loss claims that result from that. Again, hearkening back to COVID-19, we heard a lot last year and continue to hear about business interruption. And that's something that we'll hear about now too, because of businesses that may be closed due to need for restoration, repairs, things like that. There are already delays, and those are just due to shortage, frankly, of plumbers, repair people, contractors. And so we expect that that's going to be an area where we would see some increased claims. Now, if you lived through what we kind of affectionately call the mold rush, you may never want to hear the word mold or mold rush ever again. So I'm sorry to bring it up, but we are already also hearing about mold, and contractors saying, listen, if you had a burst pipe, be on the lookout, try to prevent it, but you can't. We know that there will be claims for mold. Mold is a really interesting area after the mold rush, and by that I mean there was a really landmark decision. It came out of the Austin Court of Appeals. It was the Ballard case. And this was the claim that mold had invaded the home such that the entire home suffered from toxic mold, had to be destroyed. It launched an industry of mold claims. And for a long time, those were, it was kind of, everything went crazy with it until the Texas Supreme Court brought some sanity into the equation with the Feist decision, saying, even the policies exclude mold and it doesn't come back in through an ensuing loss clause. And then it put the final nail in the coffin in the Page decision in 2010, saying, no, we really mean it. There's no mold coverage. And so now most standard policies exclude mold, may bring it back for very limited coverage. You really have to get into the nuances of the policy, but the kind of the default rule is that mold is excluded or has very limited coverage. Now, that being said, is this going to, again, be kind of the perfect storm? Is there going to be a resurgence or an attempt to relitigate mold coverage? It could be. We know that there will be claims for mold water damage remediation because, again, that's something that is just going to follow from the nature of the types of claims that we're dealing with. Other claims, and again, the something that's different from the kind of the last big round of claims, say like COVID-19, is that whereas that affected a lot of businesses that were shut down, here you've got both, you're going to have commercial claims and you have a lot of residential claims. Of course, you're going to have issues involving exclusions, coverage issues, and I would imagine lots of questions about matching and RCV, ACV, all of those kinds of things that luckily, we're all pretty well familiar with, and there's some good law out there on that. But anytime that we're talking about coverage and claims in Texas, as we all know, it goes hand in hand with bad faith claims. And so we do need to talk about that. And it's a little complicated here in Texas. We've got the common law, and we've got our statute. And but we're fortunate today because I believe we have some people who have volunteered to help us out with that. Is that right, Steve?
Correct. Thank you, Laura. Thank you, Laura. Yes, the P on the fin stand for plaintiff lawyers, and they're from the plaintiff bar, and they're here to help us. They're already having their seminars. They're getting their stuff together. We're seeing it coming up from Florida. There's a firm, 3 different folks out of that firm. There's firms in Ohio. I mean, they're all converging here. I'm going to talk to you at first about the new law, and this is important. And if you don't remember any other subject I talk about today, remember this one because it has changed things. And this just came out on April 1st of 2020. I know it's April Fool's Day, but it's not an April Fool's Day joke. It's a case called Kenyon versus Elephant Insurance. It's out of the San Antonio Appellate Court, It's good law now, but it is up before the Supreme Court of Texas. So that may change. Kenyon, the fact pattern, very quickly, the fact pattern of Kenyon is the insured runs off the road due to ice. She calls her husband to come help her. She calls her insurance company and gets their phone service. And the phone service says, have someone take pictures. And that's her standard pattern, take pictures. Her husband arrives. She has him taking pictures outside. And unfortunately, lo and behold, someone else hits the ice, runs over the husband, and kills him. We didn't think that was going to end up in an independent cause of action against the insurance company, but it did. It did. Because, listen to this, the insurance company instructed them to take pictures, made them an active part of the claim process. And if that happens and we don't remonstrate with them properly, then they can sue. Why else is this important? You don't even have to have a policy. Let's say they call you in on a claim and you tell them what to do in relation to preservation and they get injured. Turns out you don't have coverage. There's still a claim of action. There's still a cause of action for that apparent duty. You told them what to do, an accident happened. Let's look at the policy language. This is just a standard deal that's out there on one of our policies we're in, but all of them have similar language. Look at 3B. Protect the property from further loss. Make any reasonable repairs necessary to protect it. Keep an accurate record of any repair expenses. Okay? You all have that. You can take that down, JJ. You all have that in something similar to that in your policies. Now let's keep going on Kenyon. Here's a picture of a house. Lots of those in Texas. Lots of those in Texas, not just Houston. Houston had the boil water problem. They're used to just boiling corn mash and not having to boil their water. So there are a lot of angry people down there, but there's this kind of ice almost all over the state. Now watch what the homeowners will be doing. That's right. There'll be people getting up on a ladder. Grandpa will be up on a ladder and he's going to fall. And they're going to want to blame somebody. You can take that down, JJ. So if your call center, if you personally tell your insured, be sure to protect your asset. I advise you getting the tarp and throwing over it, or I advise you to do this. Be careful, because that is now, as of April 1st, 2020, that is an independent cause of action against the carrier. We're working with 2 or 3 of our carriers with their language and their policy. One in particular I can think of. We had that set out so we can email it to the insured, telling them what's in the policy, so we're not giving them advice, and to save their expenses. On that one, it's a save your expenses policy, and they can get reimbursed for it. So be careful there. There will be those problems out there. Just remember, now we have liability without coverage now. So be careful. Let's move on to one of my favorite subjects, the bad faith litigation, extra contractual. I've handled those cases for 30 years and they get tougher all the time. In Texas, we had it pretty good for a long time. Bad faith was kind of unheard of. You may have heard of the Menchaca case. It's a 2018 Texas case. Bad faith had kind of lain dormant for about 30 years. Then this Menchaca case came up, and the ability to collect on the policy and get bad faith, extra contractual damages was resurrected, made a real thing. I'm going to run through 5 things that Menchaca pointed back to, it's the Unfair Settlement Practices Act out of the Texas Civil Code. Almost every state has something similar. But the bad faith can occur if there's a misrepresentation of material fact for the policy. Guess who gets to make the decision generally if there's a misrepresentation of material fact? You think it's a bunch of claims professionals sitting up there, 12 claims professionals? Next one, 2. Fails good faith if the settlement isn't prompt, fair, and equitable after liability becomes reasonably clear. Sounds simple, but almost every case I deal with has that section about, well, liability was clear and we didn't get settled. So now, jury, what do you think about that? The third one is failure to timely affirm or deny coverage. And we've walked some fine lines with some of my clients on that situation because we didn't deny coverage because we didn't have the information we needed, and we kept telling them that we needed that information. So we didn't deny it for like 3 years. And we were fine with it. It worked as it should because we needed the information. Here's a tidbit for you to take home. You need to make sure the contacts with your insured are replete, thorough, a number of them in your file, because your jury wants to know that you've done everything you can to help the insured along. So it goes without saying that if you said you're going to call them day after tomorrow, then by gosh, you better call them. You know, if you say, I'm going to get you ABC, you better get them ABC. They may not get you what you need. You can't send them one saying, all right, you SOB, you promised me this twice, get it over here. Now it's, well, I'm sure you've been busy and didn't get to this, but I really need this so we can, move your claim along. I'd like to get this resolved. That makes it a lot easier on folks like me if our files are replete with that information of how hard we've tried and done everything right. The days, and we won't go through this today. I'll do a separate seminar, webinar on bad faith litigation because it can take forever. But it's important to keep that information for the jury to understand what you were doing and why. The third thing, or the fourth thing, is we don't see much anymore. You ask for a full release when you've only made a partial payment. I did see one of my clients even earlier this year, it was a pre-printed on the check that was a full and final release. That's a no-no. That is a no-no. And that'll get you on the Menchaca unfair settlement practices timeline. But other than that, I rarely see that anymore. The biggie is number 5, and it comes up every time. Refuses to pay without a reasonable investigation. Folks, I know how tough it is when you've got 300 claims you're working and you've got field adjusters out taking care of them. But when it gets down to trial, it's going to be, was there a reasonable investigation? You have to be so in touch with your file that in your deposition getting ready for trial, you don't say, well, yeah, if I'd have known that, I'd have done it different. If I'd have gathered that information, I'd have done it different. You only get the one chance to get it right. And you got to do it all the first time through. It sounds like a big hurdle. It's not as tough as it sounds. But you have to pay very close attention to it. Remember all those 5 elements that I just gave you. The jury decides generally what happened. If the insurance company was doing it right, or if the insurance company was in some form of bad faith. again, I'll do a full webinar on that. I don't know if that's the one next week, because Laura is wanting to do the class action, the MDL section 2. So we'll look at that. Now let's talk bad faith damages. This is why plaintiff attorneys circle like the sharks. It's not because the claim may be worth $40,000 and they want, you know, part of that $40,000. No, the claim is just the seed money to get them into the courtroom. Bad faith damages, they can collect their policy benefits if they prevail. The jury will tell you if they need to collect policy benefits. Here's one of the other biggies, attorney fees. They get attorney fees if they prevail. Okay. I have seen many cases where the tail wagged the dog. The attorney fees were 10 times what the actual loss was. I mean, I've been in $1,800 losses that the attorney fees were, you know, $500,000. The jury decides that in Texas too. They don't in other states like Arkansas and Oklahoma, where we also do our work. But in Texas, you present it to the jury as to what your expenses are and why you should get them. The other important thing on bad faith damages, mental anguish. It's hard to put a price on mental anguish. So that allows the plaintiff attorney to say, they can't do that to us people. Those companies up there in New York or those companies over in Ohio, they can't do this to us. So it destroyed these people. Their mental anguish is worth $2 million. Well, shock, shock, I've heard that number and a whole lot more for the mental anguish. All right, here's the way it all starts piling up. The limit on actual damages, you got your policy, you got your mental anguish, which is your two biggies. Let's say they total, the jury gives a total of $1 million, just to make it simple. The jury then can decide bad faith, and the case law limits it to treble damages. So that $1 million becomes $3 million on a $40,000 loss. The other thing is they get interest from shortly after they file, not the day they file, of course, but 60, 90 days, 160 days later. Luckily for storm damages like this, they should be limited to 10% interest. Now, normally on even a house loss or a car loss, it's like 18%. You talk about something that is eating you up, especially in the days of COVID, where it takes so long to get anything tried. The interest will eat you up. I don't even have time to bring it up today, but the Deceptive Trade Practices Act, they always bring that up. A lot of the rules are the same to what they can collect, but they like to throw in all the claims they can and then see if they want to weed any out as it goes to jury, or let the jury select. Laura taught me about Menchaca and the rules of it. The general rules are, if you have no coverage, there's no suit. But like everything else, even our policies, what they give us, they take us away later on. Withheld benefit suits are very common due to Menchaca. We call those the entitled to benefit rule cases. And then there's also the benefits lost rule, when they claim there's a misrepresentation of benefits. These are all just methodology to get before the jury, to see if they can make the jury mad. Let me talk about jury verdict research. I've done a little over 30 research trials. I find them extraordinarily helpful. One of the things I do is I look to see what kind of juror is in this district. I mean, I do my research trials right where it's going to be tried. So what is the mood? How are they taking things? You remember the Oklahoma tornado claims that came through. That is tough, and the jury research kind of helps us tease it out. That is tough because you're 12 people sitting on the jury. They went through many of the same things that the plaintiff went through. So it's very important to do your research trials, to know your district, to know your case, how it compares with the problems the jurors likely would have had. Folks, we have to try these cases. We have to defend them. Of that $200 billion that may have to be paid out of this deal, if we could have kept the plaintiff attorneys out of it and just paid the claims, you're probably talking about 125 billion, maybe 100 billion. That's the added cost the plaintiff bar brings to the table. So we're going to have to defend some of these. We do our job and we defend them. If we roll over, we get to pay more and more and more. And frankly, I've seen it happen already. We pay more on a property case now than we paid 5 years ago. Why? One reason is jurors are giving larger verdicts, but another is that we're settling more. Well, we used to settle for $250,000. Now it settles for $350,000 or $400,000, and now the plaintiff attorneys are saying, no, that won't do. Now we want $550,000 or $750,000. We're going to have to hold our ground on some of these, and it's the claims handling, the reporting in the file that makes that all possible. Let's before I turn it back over to Laura, let's talk about the good news. You probably heard of chapter 542A. In Texas, we call that the Hale statute. It was put in, the A is really, think of it as an amendment to the chapter 542. The insured, before filing suit, has to give proper notice to the carrier that they want to file suit. They have to give notice, what are the acts and omissions that we did? What is the problem? Don't just file it and figure it out later. What is the specific amount alleged to be owed? They have to tell us that, the specific amount alleged to be owed, for what it's owed for. And because we know they turn into attorney fee cases, they have to tell us what their incurred attorney fees are to date. We have to follow that stuff like a hawk, because if it is one that we think we need to resolve, we need to do it before it gets down the road. By down the road, I mean after they get to file it and the attorney really starts getting his hooks into it, it gets damn expensive, and then you get interest on top of it. So folks, we need to come together quickly when we get this notice and evaluate it. This is a pitch for all defense attorneys. Don't wait till you're sued to bring them in. We have kind of a, I hate to say it's a treadmill system in our office to set these things up so they're all calendared, docketed, followed, and evaluated, so that the carrier, before time runs out, can say, all right, I'll pay you that $200 on that $40,000 loss, because that's really all you got to work with. That helps take care of that section of it. Just after the 60 days, we still have a right to inspect, but we can't dawdle. We got to get right out there and do it. And we've got to have good cause. If it needs to wait, we let the court know of a plea of an abatement or the plaintiff attorney. And but we still only have a few months to get it taken care of. One other really important thing that came out with the 542A in 2017 in this part of the country, at least, people always try to add the agent to the case so they can avoid federal court. Plaintiff attorneys avoid the federal court like the plague, unless of course it's a class action or something to that effect. But they don't like federal court, they like state court, where state judges are much more amenable to their claims. 542A in 2017 set it up where if the carrier accepts the liability that may occur for the agent, then the agent has to be dismissed from the litigation, thus allowing it to be removed to federal court. We get those dates too. It is critical to get that in there. It would be a rare circumstance you wouldn't, on a big claim, that you wouldn't want to get in there and get that agent out of there, because you're probably going to be responsible for him anyway. There are circumstances we don't. I do a lot of work with folks, like Farmers Insurance is a good example. Their agents are not technically employees. They're independent agents. All well and good, but that doesn't mean the judge down in Bexar County ain't gonna leave it up to the jury to decide if they're really an independent agent or not, because they've got a Farmers Insurance email address. It's over their door, et cetera, et cetera. So it's important to get in there to docket that so you get the agent out of there in time. Save you a lot of complications. Now I've given you the bad and the ugly. Let me pitch it back to Laura to hopefully give you some good news before we go to question and answers. Take her away, Laura.
Thanks, Steve. You did give a little good. 542A is quite good. And the other good thing here is Texas Department of Insurance, as with Harvey, it's taking an active role here. 5 bulletins issued to date by my count, 3 of which are dealing with property and casualty. No surprise there. 1 is a work comp bulletin, reminding carriers and adjusters of that grace period that is the statutory part of the Prompt Pay Act that just gives 15 extra days to all of those deadlines for the prompt pay, the 15 days to acknowledge the claim, 15 days to make the decision, those types of things. Those all get extended as one might expect for CAT claims. And as I think I mentioned earlier, this obviously has been designated a statewide catastrophe. There are also some good things in those bulletins. Reminders and pointers for public adjusters and roofers. And remember, lots of issues came about during the hailstorm claims and other prior storms. And as a result of that, there were regulations put into place that were supposed to prevent, say, a roofer acting as a public adjuster and vice versa. Those conflicts of interest that were very common prior to these more recent regulations. And there's also things that, unfortunately, with every big storm, you get shady contractors and things like that. And so Texas Department of Insurance has a quite robust enforcement division. And so it's on the lookout. And so it has put into these bulletins reminders about all of those regulations that are in place. And a reminder on those prompt pay deadlines, they are not waived, they are just extended. And I'll just end on this, on 2 notes on prompt pay and on appraisal. On the prompt pay deadlines, those apply. We say it's kind of a strict liability. By that we mean if a claim is owed, if there's coverage, it is strict liability in the sense that it's not, unlike the bad faith statutes, there's not a reasonableness determination or whether there was enough investigation. It applies if there's coverage, if the payment's late. And then you're going to, and that kicks in. And for natural disaster type claims, again, it's the 10% reduced interest versus the 18% as of the 2017 statute. But some things that are helpful to note: on undisputed payments that are made, there's not going to be any interest that's accruing on those. And that's the Republic versus Tex-Mex decision. And so and that's frankly to the policy there is to encourage undisputed payments. If something's owed, make it early, make it timely, and then there's no interest. Could you possibly owe something in addition if the jury finds that more is owed? Yes, but the interest is only going to accrue on that delta. The other just kind of final note here is on the anticipated kind of avalanche of appraisal claims. Appraisal does not have to be a foregone conclusion where, to dovetail on what Steve was saying, where there's proactive claim handling and where there is a willingness to engage, continue the dialogue, willingness to revisit, get an additional estimate, take the insured up on a request to reinspect, review another estimate, things that are common knowledge and commonly done, frankly. But all of those kinds of just 101 type things, appraisal really won't be, it'll be an afterthought if it never gets to that dispute point, because there's this ongoing dialogue about coming to a resolution. If in fact there's not a coverage dispute, if it's just we're going back and forth over numbers. There's also this possible defense of the reasonable payment, and that's the Hinojosa decision. We're following that. That's up at the Texas Supreme Court right now, and that may be something else that kind of helps balance out the Barber Technologies decision, which imposes the interest even after the payment of appraisal. And I think on that note, we have time for some questions, and I'm going to turn it back to you, Kristen.
Thank you, Steve and Laura. That was very informative. A lot of new important information was gained, and I'm sure our viewers feel the same way. Laura, I will ask you one of the questions that seem to be coming up from a lot of people today, and that is, how do you anticipate the courts handling all the new litigation that is likely to spring from the big freeze, especially when the courts are already so backed up because of COVID-19 litigation, and then obviously the emergency orders in place in Texas, which have postponed all jury trials?
Right. We know there's a backlog. What I suspect, and past experience tells me, there are probably going to be the standing orders that are put into place. Like, for example, in Bexar County, after the massive hailstorm in 2016, the state courts there put into place the standing orders, and that funneled everything. It's like once suit was filed, it stopped it, and it said you have to do these required discovery, you have to go into mediation. Now, that was prior to 542A, and so that's a new wrinkle. So it can't affect things that are in federal court, obviously, but for the cases that remain in state court, I would imagine to see more of those.
Very good. Laura, another question is coming up is there a difference between a commercial and a residential claim and how they may be handled?
Well, sure. I mean, the main thing is that commercial claims tend to be higher dollar value. They tend to be more complicated, and that's just due to generally the size of the property and the structure. I tend to see more involvement of, say, public adjusters on those types of claims, and but the types of damage probably are going to be similar. The only other thing I can think of off the top of my head is, say, like business interruption. Obviously not going to be a factor on a residential claim, will on a commercial.
I tell you what I see as the big difference when you're talking dollars. The corporation does not get mental anguish damages. So when we're talking through those different elements, and trust me, mental anguish is one of them that the jury can blow wide open and then get it trebled. So it is nice on those commercial deals that they can't blow that open. Also, the jury doesn't attach to another corporation like they would attach to a homeowner. Actually, in the long run, folks, I think your homeowner's claims are going to cause you more claims headache than your commercial situations.
Well, thank you all for joining us. This is going to conclude today's webinar. Steve does have one more note before we go out.
Well, I had a friend that texted me. I don't know why he didn't, he said, Steve, what if the claim delays cause mold? Then is the damage an element of damage they can now claim and treble? Laura G., what say ye?
Well, and unfortunately, that gets into the realm of just a basic consequential damage, and that's something that has been asserted before. And frankly, yeah, you don't get into a coverage issue at that point. That's just, now you're just talking straight up damages.
Yeah, yeah. We're gonna. I was glad Bill sent me that, because it is a great point, because people think, great, no mold coverage. You're still going to see mold coming out your ears, type thing. The plaintiff attorneys put together whatever claim they can. I would like to say in closing out, this appraisal process, I know how the industry feels about it. And Laura and I, she thinks a writer's mind. I think a juror's mind. I'm working on, and we're not ready to take it live, but I'm working on a way to use the appraisal process to our advantage. And Laura G is trying to prove me that I can, I want, but she hadn't been hopeful yet. But it's a big deal if we can get the appraisal process. Some of you folks on this line are too young to remember when the appraisal process was our friend. But it morphed to where it is not our friend. And I think I've got a road to help out there. But if I don't, we'll pretend this conversation never happened. All right, folks, I appreciate you all coming forward, listening. Do email us. We're looking at jury verdicts, just on jury verdicts that the big freeze can be expected. We're also class action MDL. Laura G wants to do that, and trust me, we're going to get into a lot of MDL stuff if the plaintiff bar has their way. I don't think they'll get class actions very easily. Do you, Laura?
No.
Yeah. But it's all the same difference. They get to put 100 billion on the, out of 10 million claims or whatever. And so, yeah, insurance companies pay us 50 billion and we'll go away. It's that same old saw. The other one is my favorite, is avoiding bad faith. And that's a seminar in and of itself. But folks, we appreciate you joining us. We've enjoyed kind of bringing you up to date about what's going on in Texas. And check out our website on things. Laura keeps that up. She's got her own little booklet of all of that. And so we've got the information for you if you need it. Calls are free. Most things Laura and I and Kristen can answer in 5 minutes. Okay? So let us help. We don't open a file. We just answer that question and then we move on. Kristen, thank you, ma'am. Laura Grabouski, good work. Thank you, folks. Bye-bye.